Tonight, we're attempting to clarify the 11 issues on the 2012 ballot. And I want to emphasize, we're not here to convince you of which way you should vote, yes or no, but only to clarify the impact of the amendments and what they would mean if they passed. We've asked our panel of experts to talk about the pros and cons of them as they see them, but not to take advocacy positions. So, with that, let's meet the panel. You can read their full biographies in your program, so I won't take the time to do that. But on my immediate left is Tara Newsom, Associate Professor of Social and Behavioral Sciences at St. Petersburg College. And next to her is Aaron Sharockman, Deputy Editor for Government of Politics at the Tampa Bay Times. On my far right is Tony Carvajal, Chief Operations Officer of the Collins Center. And on my immediate right, Judithanne Scourfield McLauchlan, Associate Professor of Political Science, University of South Florida, St. Petersburg. And our moderator for this evening is Dr. Frank Alcock, a professor of political science at New College of Sarasota and a former senior fellow with the Collins Center for Public Policy. He also serves as a political contributor for ABC News in Sarasota and CBS News in Tampa, St. Petersburg. And he will start by explaining the background of the whole initiative and amendment process for you, and then he'll take up the individual amendments, giving a synopsis of it before turning it over to the panel. And we ask you to save your questions until the end so we can be sure to get to all of the questions. For your convenience, we provided an insert in your program that lists just the titles and the names and the titles and the numbers. Dr. Alcock.
Okay. Thank you, David. Can everybody hear me fine? Okay, I'm going to move fairly quickly because there's so many amendments on the ballot this year, and I'd like to preserve as much time as possible for your questions at the end. I just want to make a few points about the constitutional amendment process in Florida. Not too many, but I just want to deal with some of the questions that we usually get, or I usually get, right up front. First one, the ratification threshold for the citizens of Florida is now 60%. So on election day, you'll need to have 60% voter approval for any of these 11 amendments on the ballot in order for them to go into the Constitution. Now, I get some questions sometimes with respect to what if I don't vote? How is that going to affect? Is it 60% of the total votes, or is it 60% of the people that walk into the ballot box? Let me be clear. It's 60% of the votes cast. So just a quick little math lesson here. I know you don't like the terms numerator and denominator, but if you come in and you cast a yes vote for any of the amendments, then it's going to be +1 for the numerator and +1 for the denominator. It will increase the percentage. If you come into the voting booth and you cast a no vote, it will be no change to the numerator. You'll get +1 on the denominator. It will lower the overall percentage. And if you choose not to vote on one or all of the amendments on the ballot, it will neither affect the numerator or the denominator, so it won't have any effect. A second, I think, very important point about this year's constitutional amendments: all 11 of the amendments on the ballot are legislative initiatives. There's a variety of ways to change the Florida Constitution. I'm not going to get into a history lesson, but an important distinction between legislative initiatives and what you might be familiar, there's citizens' initiatives. Now, citizens can come together, and if you collect a certain percentage of signatures, a percentage within each congressional district in the state of Florida, you can put something on the ballot to change the Florida Constitution. If something is a citizens' initiative, it has to abide by a couple of rules. One is something called the single subject rule, which is your amendment to the Constitution can only deal with one single substantive subject. And then with respect to your ballot summary, if it's a citizens' initiative, it must be 75 words or less. Now, the Florida legislature, for better or worse, is not bound by any of these rules. And so when they put together amendments for the ballot, they have the discretion to make them single subjects, or they can package together multiple substantive elements. Tonight we're going to talk about a few of the amendments have more than one substantive element, and they're packaged together in a single amendment. The final point, and then with respect to the ballot summaries, the legislature doesn't have to restrict itself to 75 words, and we have a few amendments on the ballot that actually have 600 plus words in terms of the ballot summaries, and sometimes there are a lot of legalese, and so we'll do our best to try to cut through that tonight. One last point that I want to make about the constitutional amendment process, or the Florida Constitution in and of itself, is that there's some frustration sometimes on the part of the public, which they look at what they view to be minutia and things that have no business being in the Constitution being put on the ballot. I just want to remind folks that our federal Constitution, which is a very spare document in terms of its overall words and sort of setting up the different branches of government and their powers and their responsibilities and our basic rights, it's a poor analog for what you see at the level of state constitutions. Anything and everything can be in a state constitution. What ends up as a statute and what ends up in a state constitution, it varies from state to state. The Florida state constitution, very, very different than our federal constitution, but not all that different than other states. We're not necessarily an outlier in terms of our state constitution with respect to other states in this country. Now, one of the areas where you have a body of law that for peculiar historical reasons is in our Constitution are property taxes. And so, if you want to make a change, no matter how minute, to property tax law, whether you like it or not, you have to go through the state constitution. Tonight, out of the 11 amendments that are on our ballot for changes in the state constitution, 5 of those 11 amendments deal with property tax law. And what I'd like to do, just in terms of the sequencing tonight, I'm going to package those all together, and I'm going to deal with those first. And those are amendments 2, 4, 9, 10, and 11. And I'm going to try to give my panelists a helping hand and just do an overview of the substantive elements for each of these 5, and I'm just going to rattle right through them one at a time, and then I'm going to try to get their opinion, what they view to be the strengths, weaknesses, pros, and cons of the package, or particular amendments within that package. So let me start with Amendment 2. Amendment 2 is a property tax discount for disabled veterans, and what it is, it's a change in the eligibility criteria of an existing property tax discount that's already in the state constitution. If you are a senior, 65 years and older, a disabled veteran, if you incurred your disability as a result of a combat injury, and you were a resident of the state of Florida when you incurred that combat injury, you are eligible for a property tax discount that's commensurate with the degree of your disability. Everybody that's disabled has a 5% discount that they're eligible for, and if you have 100% disability, you get a full waiver of your ad valorem taxes. But in between, if you were a Florida state resident when you incurred your disability, you get a reduction in your ad valorem taxes that is equivalent to your disability. What this amendment will do, it will waive that residency requirement when you incurred your combat injury. So for instance, if you were an Ohio state resident, you were injured in, say, the first Gulf War, you moved to Florida, you have a 50% disability, right now you're not eligible for this discount, that will waive that. So regardless of where you incurred, what state you were a resident of when you served and incurred that injury, now that you are a resident of Florida, you moved to Florida, you will be eligible for this property tax discount. With respect to the fiscal impacts for each of these, I'm going to refer to the State Revenue Estimation Committee estimates. They meet periodically over the year, for better or worse. Some of these estimates tend to be pretty precise, and there's a high degree of confidence. Some of them, there's a lot of uncertainty associated with them. This is one of the ones that there's a good deal of uncertainty associated with it, just because of degrees of disability and whether disabilities were actually incurred in combat. But the State Revenue Estimation Commission estimates that the statewide fiscal impact would be $2.5 million the first year, up to $5 million, and then $7.5 million by the third year, and that's where it would level off. And this would be statewide. High degree of uncertainty, the degree to which you might get higher concentrations in areas that have a lot of disabled veterans, a lot of uncertainty with respect to that. Let me move now to Amendment 4. Amendment 4 it starts off property tax limitations, and then it goes into a very long title, and I'm not going to recite the entire title. There are actually 8 relevant changes to property tax law on the ballot. 4 of them are packaged together in Amendment 4. And so as I said before, the legislature can package together multiple substantive elements. They've done so in Amendment 4. The 4th one I'll leave to the side for a second, but the first 3 are actually probably the most substantive changes to property tax law on the ballot. The first element has to do with homesteaded properties, and it is a prohibition on recapture. And what that means, let's just say that you have been benefiting from the Save Our Homes Act for a considerable period of time. You might be in a situation where the assessed value of your home is considerably less than what the market value is, but over the last couple of years, market values have been declining. Nevertheless, there's still that gap between what the assessed value is and the market value. What the state would do, your assessed value can continue to go up to sort of, quote unquote, recapture some of that discrepancy in terms of the market and the assessed value. This change would prohibit that. So in any year where the market value of your home declined, the state could not recapture it. Your assessed value could not go up. The second substantive element is for non-homesteaded properties. Right now we have a 10% cap on how much the assessed value for non-homesteaded properties can increase per year. This would reduce that to 5%. So from 10% to 5% for non-homesteaded properties. The third substantive element within Amendment 4 is something known as it's a new home buyer. It's an additional tax break for new home buyers. Not only new home buyers, if you haven't owned a homesteaded property in the state of Florida for the last 3 years, you would be eligible for this property tax discount. What it would be half the value of the market value of your home, limited to the median value within the particular county that you reside in. I'm from Sarasota. Right now, the property values, the median value is down on $150,000 per year. A few years back, it was over $300,000. So it's a considerable, and there's some uncertainty. There's a considerable difference right now. Right now, the maximum that anybody could sort of claim under this new exemption if they bought a new home, even if it was a multi-million-dollar home, would be an additional discount of half of, say, $150,000, which would be $75,000. If the property values go up and double, then that median's going to go up, and it would be considerably more. This would be phased out over 5 years. And so if you buy a new home, initially you'd be eligible for 50% of the value of your home subject to that median value, and that would be reduced $20,000 per year and then be phased out over 5 years. The fourth element is simply taking something that's already in the property tax law from an earlier amendment and pushing back the expiration date from 2019 to 2023. Very importantly, some folks are concerned about fiscal impacts. With respect to everything that's on the ballot in property taxes, well over 90% of the fiscal impacts are wrapped up in Amendment 4. And so the State Revenue Estimation Commission, over the first year, their estimate is $158 million, and then over 3 years it ramps up to close to $570 million per year in impacts to local government revenue. It's over $500 million a year. And to put that in perspective, it equates to, on average, about 5 to 8% of local government budget revenue. So it's considerable fiscal impact, and that's in Amendment 4. In Amendment 9 is a property tax discount for surviving spouses of military veterans and first responders. There's actually a rogue law on the book. Since 1997, we've had a statute that actually waives ad valorem taxes for surviving spouses of military veterans. But as I had mentioned before, if you want something like to be valid, you have to go through the state constitution. So in part, you might look at this amendment as trying to correct a prior rogue law by putting it in the state constitution. They've actually expanded it to include surviving spouses of first responders for both military veteran surviving spouses and first responders. Either the death had to occur in either combat or in the line of duty for surviving spouses. With respect to fiscal impacts, this is the lightest of them all. It's less than $1 million a year statewide. Amendment 10 has to deal with tangible property taxes. You're all used to paying property taxes on your home. However, if you own tangible property which you use for income-generating purposes. Now, who would that be? Well, let's just say maybe you're a small business operator and you have some equipment that you use for the purposes of your businesses, but it's not owned by a business entity, you own it personally. Then you are required by law in the state of Florida to report that, and it's subject to taxation. There is a $25,000 deductible, so if the value of your tangible personal property used for income-generating purposes is $25,000 or less, it comes under the deductible. This would increase the deductible from $25,000 to $50,000. The revenue estimation impact statewide is $20 million per year. It's pretty flat over the course of the history. Finally, Amendment 11. Amendment 11 is a property tax discount. It's actually a full waiver on ad valorem taxes for long-term resident, low-income seniors. This one has the most criteria attached to it, and let me walk through them one by one. If you are a senior, 65 years of age or older, you are low income, defined $27,000 of income a year or less. You have lived in your home for 25 years or more, and the value of your home is $250,000 or less, then you are eligible for this new property tax discount, which would be a full waiver of your ad valorem taxes. Now, unlike any of the other 4 property tax amendments, the legislature decided to put a clause in this one whereby county commissions or city councils actually have to approve this before it goes into force. The budget impact for this, according to the State Revenue Estimation Commission, is on the order of $9 million and change, a little less than $10 million per year, and it's fairly flat over the first 3 years and the horizon. So that's quickly running through all 5 property tax amendments, a little bit about who they mean, what the eligibility criteria are, and what some of the fiscal impacts are. Rather than simply give you my take on pros and cons, I'm going to go to now my esteemed panel. From your left to right, or my right to your left, let me start with Tony, and I'll just ask everybody the same question. What do you like about this package and or particular amendments? What do you not like and why?
I'm going to avoid talking about my personal opinions or really how to vote on any of these, as most of the other panelists will. But what we'll talk about is generally how they all tie together. And what I'd like to point out is the Florida Constitution, while it's complicated to put things like this in there, it is a document where you can enshrine what is valuable to you. So when you look at something like how do you want to treat veterans, which, by the way, is a big part of the growth of Florida since the 1940s, or when you talk about surviving spouse and first responders, this is the place where you're going to tell future generations what you value. It also, many of these things start getting to what's going on in the background, and that is there's a fundamental shift going on in how we view taxes. Over time, what we have had is a situation where we like taxing people who are not in Florida most of the time, residents who only come in here part of the time, who own property, non-homesteaded property particularly. Businesses have carried the burden of a lot of the taxes at a lot of time. We're now in a fundamental discussion about what is an appropriate tax. Yes, taxes are inequitably applied in the state, but they're going to continue to be inequitably applied. It's just a matter of how you want them to be inequitable. And those are the things that are being addressed by these constitutional amendments. Those are choices that the public should make.
Judithanne, some reactions to the property tax?
Well, I'm not an economist, and I've been trying to get some good figures as far as the economic impact or revenue loss that would be generated by these amendments. But I did want to say one thing just in terms of thinking about voting on constitutional amendments in general, and respond to something that we said about the difference between the U.S. Constitution and state constitutions and their purpose. The U.S. Constitution, as I'm sure you know, is the oldest constitution in force in the world today, and I brought it just for show and tell. So it fits on one page, whereas this is our Florida Constitution, which is the 6th Constitution we've had, and it's quite a lengthy document. And
my understanding is the Alabama state constitution is about 3 or 4 times longer than ours. Wow. So we're bad, but we're not that bad.
Yeah, so I guess it's all relative, but we, the voters, are going to get to decide what is it that we want to be included into this document, because the Constitution is a Constitution, and it's a founding document about how our government is going to be organized and the distribution of power, et cetera. And so I think sometimes we end up with policy choices. Pregnant pigs is probably the favorite example to use, because you think, is that really part of our founding document? So a number, and I guess the other thing I would say, and I know we need to move on, about the taxes and the, Amendment 4 estimated about $1 billion over a 3-year period to
Correct.
the
And then
Amendment
about a little
9
over $500 million a year after that.
for the Amendment 9. But so there's a significant impact in a time of revenue loss and significant budget deficit. So I think it's something to consider when you're considering whether to approve these individual amendments, is the impact it's going to have on the budget process in the future.
Tara?
I think it's important to realize that your Constitution is your social contract. It's your way of engaging with the government in a way that expresses your priorities. So when you vote on these constitutional amendments, and when you look at the revenue loss that's going to happen with them, you got to think about what is that going to translate into the outcomes. If there's going to be a revenue loss, that means some program is going to be cut. And you might be okay with that, but you aren't at this level being able to figure out what that will mean in the cuts. You can't figure that out at this point. So you ultimately have to understand this is your social contract. These cuts will affect how the government delivers services to you. And as our recession continues, are you ready for those priorities to be made on the state legislative level? This constitutional amendment allows that to happen. So I think that you got to think about the outcomes. If we're going to cut them through these amendments, what's that going to mean to you as a citizen and to the rest of the state? If you have certain priorities that you think are already underfunded, you certainly have to think what Judithanne said about $1 billion being cut in the next 3 years is going to have a more dramatic effect on those programs as well. So as we talk tonight, think about these amendments and how the outcome is going to reach into your lives, into the things that are important to you, because that's really important. These aren't just cerebral, esoteric amendments. These are things that are going to reduce the income to the state revenue, which will then result in cuts. And your efficacy in directing those cuts is a challenge already. So you got to just think about that.
I'll talk about the politics a little bit. It's my nature. I find these 4 amendments, 5, quite interesting. Here's why. Last night we had a debate between a Republican and a Democrat running for president. I imagine most of you saw that. The Republicans' plan is to simplify how we pay taxes. Yet the Republicans in Tallahassee, different mission, are going to make this more complicated, how we pay taxes. I think that's one point. To me, it's just interesting. One of the things that I want to point out, too, as well, is what the legislature here is doing. I might give them a Profile and Courage Award. These are Tallahassee lawmakers who rely on their $70 billion budget largely by the state sales tax you pay. So whether this passes or not, they can still hand out the goodies. Where it impacts is at the county level and at the city level. And that's why in the cities y'all live in, you're hearing your local folks saying, we have to cut, we have to cut, we have to cut. And so in St. Pete, where I live, the city council and the mayor said, oh gosh, we don't have enough money. So guess what we're going to do to make things work? We're going to raise our millage rate. We're going to collect more revenue to make things work. So one of the things that's interesting to me is here you can like everything about, say, Amendment 4, because maybe you would qualify, you would benefit, it would be good for you. But it can come back down the road and bite you on the other side when Bill Foster or another mayor says, we're going to have to raise the millage rate to essentially offset the money we're losing right here. And so those are all, again, none of these decisions happen in isolation. I look at these amendments and you could say, gosh, who can be against a discount on property taxes for a disabled veteran? I mean, really, no one's against that. But again, none of these decisions are made in isolation. I think that's a good point, and especially when you look at how these things trickle down and the difficult decisions we have to make to balance our priorities. But also, just circling back, it's interesting, in all of these cases, these were all Tallahassee-driven ideas for outcomes that really won't affect the lawmakers in Tallahassee and the decisions they make.
Since we're doing so good on time, and I've got a little bit more time for my property tax amendments, I want to come back to, I think, a few of the tensions that I see within the pro-con arguments. I just want to spell them out. You've hit on a couple of them already, but let me spell them out, and then I'll come back down again. You don't have to comment, but I'll just see if you want to. I think you were just touching upon a tension that I've seen with respect to, I'll just call it the concern over our Swiss cheese property tax code. And in one way of looking at the changes are you're continuing to increase the size of the holes and take more divots out of the Swiss cheese. That juxtaposed with, there are some groups or some particular segments of our society that are worthy of special considerations, whether they be surviving spouses of first responders and military veterans who could be against that, or low-income seniors that have been living here for a long period of time, or disabled veterans. You broaden that out with respect to the tangible property tax deduction increase to small business owners, and then you get into broader groups in terms of homeowners after that. But that's one of the tensions. Another tension, Tony, I think you were talking about it, inequities. On both sides, disparities in the tax code and what this would do with respect to disparities, I think it's interesting to take a little bit of a look. When I look at the 4 amendments, I can make arguments that there are elements here that reduce disparities. There are elements that actually prevent natural market reduction in disparities, and there are some potential elements that might make some disparities worse, and let me just comment on a couple of those. With respect to reduction in disparities, there have been concerns about those that have homesteaded properties and that have been protected by Save Our Homes, contrasting them with both new homeowners and or owners of non-homesteaded property. By reducing that assessment cap from 10 to 5%, you're bringing in line non-homesteaded properties, the rate at which their assessed values can increase closer to the non-homesteaded property owners. And actually, by providing this additional benefit for new not first-time homeowners, but just new home buyers that haven't had a homesteaded property, again, you're reducing that disparity there. Nevertheless, that first provision against recapture, in a way, it's those that have been protected by Save Our Homes when market values are increasing, that when market values decline, then that actually it's an opportunity for the new home buyers to have reduced tax assessments, whereby the old-time folks that have been benefiting from Save Our Homes would naturally be subject to recapture. This blocks that from happening. So in a way, it's blocking a reduction in disparity. And then there's also, we have disparity in terms of newer home buyers and then those that have been protected from Save Our Homes. When you get to the non-homesteaded properties, you might be setting up a situation whereby somebody that's been protected, if this is passed for, say, 10 years, there's a nice gap there then between what the assessed value of their non-homesteaded commercial property or rental property is, and then what somebody would have to pay taxes on if they were to come in. So there's potential there for increasing a disparity between new and long-time non-homesteaded property owners over time. The last tension that I'll just point to has to do, certainly there's a lot of folks concerned with the fiscal impacts, especially how local governments would fare. I'll just point out again, over 90% of the fiscal impacts are wrapped up in Amendment 4. But I think one of the pro-arguments that I don't want to get lost has been pushed by the realtor sector in the real estate industry that has made the argument that, in a way, I haven't used the word stimulus, it has a little bit of a negative connotation here in the state of Florida, but one way of looking at this, it equates to it's a real estate stimulus or housing market stimulus package, trying to incentivize transactions in the housing market and investment within a property in Florida. So there's those tensions, the 3 of them. Just last word on that?
Yeah, I would say, and if you don't like the inequities, just arguing against myself, I would say we built that. We built the inequities. It was Save Our Homes, which was citizens-approved, an initiative that started this whole process that really created an inequity. It was our really joint decision as Floridians to not have a state income tax that kind of generated all this discussion. So I think we all agree we have an imperfect system, but it is our system. And so now it's finding a way to best balance kind of what we need for the government to function and provide the services we want. And then also, how do we be compassionate to people in one situation or another? And so I think that's the balancing act.
Tara, last thoughts on the property tax?
You know what, I just think that you have to fundamentally understand that when you lose revenue, you lose programs. It's outcome driven. I'm more of a pragmatist. It doesn't have to get more complicated than that to me.
Judithanne.
Building on what Aaron said and Tara earlier, I think amendments ask you to do a very difficult thing, and that is balance your own pocketbook and your own situation against the long-term interest of the state. And these are very difficult questions, and oftentimes people walk into the ballot box thinking about, how is this amendment going to affect me? Is this going to save me, a few $1,000s this year, without thinking of the larger global complications that come with that? That's one argument possibly that sounds like it's against, but the other side of that is that there are people that are talking about the restructuring of government and how we have to fundamentally think about things differently. And if we can't change the demand side, people always will want more services. You will want more roads, you will want more things in your communities. Then we have to address it from the supply side. And I think that these are fundamental questions. I encourage you not to just walk in and think about your own pocketbook in the situation, but think about what you are considering for the state. And I'll maybe building on that, what I'll say is, all your decisions on these constitutional amendments are long-term. They are not just for the next 1 or 2 years. Yes, there are ways that we can amend that, either by withdrawing it later or the Constitutional Revision Commissions, but these social contracts enshrine things for the very long term. And when you start thinking about, what the future populations look like, there are going to be more people who are veterans, there are going to be more seniors, and all of these start multiplying. So looking at a fiscal impact of just 2 to 5 years is not always the best way to calculate some of these tax exemptions. I'll end there. Thanks.
Okay, so I'm going to take the property tax amendments, just park them. We can come back to them in the Q&A section, and I'm going to move on to all the rest of the amendments, and I'll just follow them in the sequence that you'll find them on the ballot. And I'll start with Amendment Number 1. It's titled the Healthcare Services Amendment. This one's fairly straightforward. It is an attempt to ban or block the implementation of the individual mandate within the Affordable Health Care Act, otherwise known as the Obamacare Act, within the state of Florida. Given the recent Supreme Court decision which upheld the constitutionality of the Affordable Health Care Act, there does appear to be a little bit of a problem on the surface, which is it would appear that if this amendment were to pass, it would run afoul of something known as the Supremacy Clause within the federal Constitution. So I'm going to turn to Tara and ask, can you help me clear this up?
Well,
can they do this?
Well, let me just say this first. I can't go on without talking about something that Tony said and something that Aaron mentioned, which is the concept that all of these amendments deal with federalism issues. And we saw it last night with the debate. And that was the ideological rift last night, wasn't it? One candidate was for states' rights and one candidate was for a strengthening of a federal government. And we've had that conversation since the time of the Federalist Papers and the Anti-Federalist Papers, so it's not anything new. And Amendment Number 1 is just an extension of that when it comes to the Patient Protection Affordable Care. And we'll call it Obamacare because President Obama said it's okay to call it that, so we'll call it that. And ultimately, what happened in June of last year is that the United States Supreme Court said 26 states, championed by the state of Florida really, who fought against national health care reform, you're wrong. This is constitutional. And so since then, 47 states have tried to do some sort of legislative action to change that conversation, to sort of thwart the Supreme Court's efforts. 3 states, Florida being one of them, Florida, Alabama, and Wyoming, decided that, hey, we're going to codify this in our own social contract. We have the 10th Amendment. The 10th Amendment says if the federal government doesn't take it on, the states are left to do it. So we're going to go ahead and codify it in our state constitution. And that's what we're doing right now, right? That you're about to vote on whether the state of Florida, if you vote yes on this constitutional amendment, you're saying no to federal health care reform, with the individual mandate being the most controversial component to it, okay? So ultimately, though, is this symbolic? That's what really we're talking about, right? Is this symbolic? Because we have the Supremacy Clause, right? The Supremacy Clause says that the federal government is supreme over everything else. Except we have this underlying tension that we saw in the debates last night and in the movement of this constitutional amendment, which is states want states' rights. It's back to the original argument that we had at the Constitutional Convention, right? Well, the problem is that the Supremacy Clause will trump this constitutional amendment. It's clear from case law that the Supremacy Clause will say, no, this constitutional amendment probably will not be upheld. So are you just investing your vote in something that will have a lengthy and expensive legal challenge? However, before I finish that conversation, I want to say you also have an opportunity, though, to send a signal. Because even though 47 states have instigated legislation to say, hey, we don't like this federal legislation, there are 7 states that have done something very interesting. They have decided to come up with something called a health care interstate compact. Now, those of you that can remember your Constitution, it's very clear in the United States Constitution that states can get together and have interstate compacts. It's clear that we have that ability between end states' rights, okay? So states trying to get away from Obamacare being applicable have said, well, we're not really sure about this kind of amendment. This amendment looks like it's going to violate supremacy rights. We're not going to invest in this amendment. We're going to invest our time in creating an interstate compact on health care. And lo and behold, right now the Supreme Court is hearing a case, Jaffe versus the United States, that's looking at whether interstate compacts are a priority over the Supremacy Clause, or if the Supremacy Clause ultimately trumps interstate compacts. Now, I just want to say, if you vote no on this to send a message to, your state legislators and the federal government that you don't want health care reform, you don't want the individual mandate because you want states' rights to determine this kind of thing, which is
That would be a yes.
Yes, I'm sorry. Yes, thank you. I'm sorry. It's going so fast. Yes, thank you. Thank you. I don't want to screw you up. But yes, then ultimately what you're also doing is you're coupling that power of that through political consultants and the media who are going to look at that and report on that. And there's going to be a national dialogue that's going to continue on the fact that we have a huge disparity in this country on whether we want this or not. Now, will it ultimately mean that Florida will not have to implement the Patient Protection Affordability Care Act? No, we're going to have to implement it. But down the line, will it be ripe for rediscussion if we send this message coupled with the Supreme Court deciding about these interstate compacts? I think that's worth something, because that's worth the continuation of this federalism discussion, because that's ultimately at the basis of all this ideological rift that we have going on. Are states allowed to do what they want to do? Mm-hmm. So to answer your question shortly, if you vote for it, I think it's a symbolic vote, but I think that it's a meaningful one that you need to take seriously, because that's the serious conversation that we're having.
Tony, direct question. Should we be using our state constitution to send political messages?
I won't do like the political candidates and redirect this to the economy, but the state constitution is a very difficult place for us to put legislative arguments and individual arguments like those, but it is one of the only means that sometimes we have. And if you want to codify it over the long term, that is your best bet, because the legislature can always come back and change a law. If you want to make it difficult, then you got to put it in the Constitution.
Judithanne, any thoughts?
Well, I guess I agree with the comment that it would be a symbolic vote, because the question of whether the individual mandate provision of the Affordable Care Act is constitutional has been decided by the U.S. Supreme Court a few months ago in June. And so if the Affordable Care Act continues to be law, we're bound by it. So whether we pass this amendment or not, it doesn't actually mean anything as far as...
Can I ask you a question? Just sort of dawned on me right here. If passage of this law were to violate or run afoul of the Supremacy Clause in the federal Constitution, why wasn't this thrown off the ballot? I think I have the answer to that, but I want you to comment on it. Why was it not challenged prior to coming on the ballot and taken off the ballot?
Well, the decision came down in June. I don't know if it came down after the deadline for... Right. I mean, that was what I assumed, that it came down after the Supreme Court. I think it came down, the decision came down after the deadline, didn't it?
To withdraw it, yeah.
To withdraw it?
Yes.
So...
Had it come down earlier, would this be, and this might be more of a procedural question, not being a constitutional scholar, I don't have the answer to it, but I was under the impression that if somebody, in terms of putting something on the ballot, did something that ran afoul of our state constitution, our state Supreme Court would throw it off the ballot, but if there was some sort of conflict between a change to the state constitution and the federal constitution, that would not be dealt with until it passed. Is that accurate or inaccurate?
That's accurate, because in order for the U.S. Supreme Court to rule on it, there has to be an actual case, so we would have to pass it, and then it would have to be litigated, and then it would go to the Supreme Court.
Which is why it's on your ballot.
Yeah.
Aaron?
Just a couple quick little notes in the politics on this one. This amendment is on your ballot thanks to Senate President Mike Karadopoulos. It was when he became Senate President in 2011. This was his first priority to get this on the ballot. As the political junkie that I am, I feel pretty certain that he wanted this on the 2012 ballot, thinking his name would be next to it, running for the U.S. Senate. He dropped out of that race, and we haven't heard a lot from him since, to be honest. When asked these specific questions, why is this question on the ballot? It doesn't seem like it'll do anything. We never really got a straight answer. Now, I think there is one scenario in which it may impact something, and this is kind of getting down the road, but Mitt Romney's elected president. We get a Republican Senate, a Republican House, enough votes to repeal the Affordable Care Act, what is Obamacare. In that scenario, if there is no mandate, right, what I believe this amendment would do, and correct me if I'm wrong, it would prohibit the state of Florida from creating a mandate like there is in one in Massachusetts. So that it would be applicable at that point. So
That's right.
yeah.
If
I mean, but that's got to get down the road to get there. But
Okay, we are done with Amendment 1 for the time being. Now we're going to move on to Amendment 3. It's titled State Revenue Limitation. And what this amendment does is actually changes the formula to an existing amendment to the Constitution on state revenue limitation. We have a balanced budget amendment in our state constitution, and we also have something that's known sometimes as a TEL, a tax and expenditure limitation, or sometimes folks call it a smart cap. Regardless of how much money you take in, it's a cap on how much money the state can spend. We put the current amendment in the Constitution in 1994, and when we did it, we put the most common formula in there, and that formula was based upon personal income, average personal income, and income growth. Now, since that time, since 1994, income growth in Florida has been pretty impressive, and tax rates have actually fallen. And so the current revenue limitation formula has not put any sort of constraint, hasn't been much of a constraint on spending in the state of Florida. The balanced budget amendment has, but not this TEL or revenue limitation thing. What the legislature would like to do is they would like to change the formula and convert it into a more restrictive formula, one that's not based upon personal income, but rather based upon a combination or index based on population growth and inflation. This has been tried in a few other states. We'll get some opinions on how it's worked out. There's been a controversial case in Florida. I'll just note ahead of time there's some important differences between what the state legislature of Florida has tried to do and what they tried to do in Colorado. Same stringent formula in both cases, but there's some provisions in the Florida case that really got them into trouble that were avoided in the Florida case. It's interesting to point out the State Revenue Estimation Commission does not believe this will affect or put any sort of constraint on state revenue spending until around 2019 or 2020. At that time, based upon a rebound, a projected rebound, hopefully a rebound in the Florida state economy, it may come into force. Now, there's a couple of interesting provisions in this amendment. The first is at the point where that amendment, that the new cap on revenue spending were to kick in and you had some surplus revenue coming in, that revenue would not automatically go back to you in a little bit of a rebate. What that would do, originally the state wants to backfill something known as a financial stabilization fund or a rainy day fund. Once that gets up to 10%, that would be filled again. Then there's another clause to this amendment whereby excess revenue after that would be used to offset some of local government education fund revenues. It would drop the millage a little bit. Once that were reduced to zero, then you might get your rebate checks. So a lot of complexity in this amendment. As I noted, we already have a balanced budget amendment. We already have a spending cap amendment in our state constitution. So I'm going to come back to Aaron, and I just throw it out there. Is this necessary?
Republicans in the legislature say it is, which is ironic. I love pointing out ironies because their examples for why it's necessary is the Republican-led legislatures of the previous decade.
They can't constrain themselves.
That's right. In which still many of them who serve today served back then. This is really kind of an interesting case, and I'll start by saying that you have a couple things here that are happening. If you heard the buzzwords here that one, the first excess revenue would go to the stabilization fund. The legislature in recent years has made a significant effort to try to put money aside, and they have done that. The second is they talk about how money after that would go to essentially pay down school taxes. What's interesting to note there is that the legislature over the past decade has sizably shifted how schools are funded in this state. Sizably shifted away from the state and to local governments. The state contribution and the state contribution I think used to be more than 60%. I think it's now flipped, and they're contributing about 40. Local governments are paying for about 60. But I'm a smart guy, and I think when I read that amendment, the long summary, part of what I'm saying is vote for this, more money for schools, right? You're also saying don't collect more than you need, which is a great principle, concept. But the problem is, to me, one of the challenges is how this is measured. It's measured in GDP growth plus population growth. Today, typically, generally, it can be a small number, right? So it can really cap how much revenue you can increase year over year over year. Why does that become a problem? Because that has nothing necessarily to do with the cost of things, right? The cost of things can fluctuate. Healthcare cost has gone up sizably, faster probably, I would guess, than GDP plus inflation. For one example. Another huge thing is that, again, this is an amendment that actually has gotten some coverage in our paper and others across the state, is because a lot of social service providers feel very threatened by this amendment. They say that the revenue limitations essentially would force the state to make further cuts potentially down the road. And in those cases, as we have seen in the last 5 years, the cuts predominantly fall on the wants versus the needs. And so there's a large group who are opposing this amendment. At the end of the day, the state, as Frank said, like most states, have a very stringent rule in that they cannot spend more than they take in. They must balance their books every year. And in the state's interest, you have to remember that the state really, they collect revenue lots of ways, but really they collect revenue mainly through one thing. It's the sales tax. And so the state doesn't have a lot of mechanisms yet to really increase revenue. Where they will get more revenue is when people spend more, when the economy is thriving. And that's why we were where we were 2003 to 2006. The budget grew sizably each year. Legislators had more money to spend. Governor Jeb Bush had more money to spend, and we saw good times, happy, everything. And they didn't have to raise taxes. In fact, they got to cut a lot of taxes. But it's mainly because of how the state collects its tax. It collects 6% out of everything you pretty much buy, right? And so, to me, the balancing act here is you have to think about that's how they're not going to lower the sales tax, I don't think. And it sounds like the idea of you getting repaid is pretty small. So you're basically looking at the status quo, yet there is some threat that if you reach this cap, that there's going to be some cuts that you might see as a result.
I'm just going to take a step back and scan my panel. If this does come up to the extent, and if another panel deals with it, or if there is any political advertisements, you may hear something about the quote-unquote the Colorado case. Is anybody comfortable here maybe talking a little bit about that? I can come back to the facts myself.
I'm happy to talk about it. I mean, I'll just say, and real quick, this was tried in 1992 in the state of Colorado. It was called the Taxpayer Bill of Rights. TABOR is what you might know of it, and you can Google that. Same stringent cap. Essentially, it was very, very restrictive. Same general concept, but there are differences, which I'll mention at the tail end. It got bad. It got so bad that the state of Colorado essentially had to rescind it in 2005, that the cap just wasn't working, that the state couldn't really function, so they had to lift the cap. Now, there are two different, the big differences for me here is that the lawmakers gave themselves a way out with a supermajority vote to kind of, they can lift it. Or they had citizens through a referendum will be able to lift the cap as well. I'm going to ignore the referendum because I really don't think if this passes, I assume it's going to be very hard to lift it in a timely fashion. But if there was an emergency of proportions that the lawmakers realized, gosh, we need more money to fund the Florida Highway Patrol. or maintain the interstate system. There would be mechanisms where the legislature could meet. They could pass essentially a resolution, and then they could lift the cap, raise more revenues as they need to.
This will give me an opportunity to point you to our website, collinscenter.org, because on there, for each of these amendments, we have a write-up, and on that write-up, which I'll tip my hat to Tom Arthur, editor at the Tampa Trib. Tom, are you still here? Because he did a fantastic job, former colleague of mine at the Collins Center, did a great job summarizing all of the amendments. But on this one, it does talk about the ratchet down effect, and the difference is that the Colorado situation was based on the previous year's revenue, and the budget just basically kept estimating off of that. So when it started going down, the only way to go was down. We're basing it still off of an estimate, a separate number, not the previous year's finances. And that goes to the point, the 2 points that I'll make, and I think Aaron was pointing this out exactly, was that this was called the Taxpayer Bill of Rights because fundamentally people are trying to make a decision about how do you control the growth of government, and this is one of those attempts to try and do that. Those that are against, as Aaron pointed out, say that we just don't have movability in critical times. Here I will actually tip my hat also to the Florida House because in their bill analysis they actually put pictures, and it's a great look at what the impact of the legislation would do. So if you go to our site, collinscenter.org, and link to the bill analysis, you'll see some comparisons of what the various proposals, the current state and the proposed state would do. There was one other thing that I was going to point out that has not been mentioned yet and doesn't often get mentioned. We will be resetting everything to this fiscal year. So whereas I think we go back to 1994 in terms of our base and calculating these limits, we are now starting with a lower number. Obviously, the recession has dropped our current budget and revenue numbers. So a significant element in my mind is that we are resetting from this year rather than sometime when maybe the revenues would have been a lot higher, for example, 2004, 2003, sometime in that era. So,
Thanks, Tony.
Thanks.
Judithanne or Tara, anything before we move on to Amendment 5? Okay, we're moving on to Amendment 5, real simple title, State Courts. This is one of those amendments that has multiple provisions. There's 3 substantive elements to the State Courts Amendment. The first change would be to require that our Florida Senate confirm governor's choice's nomination for an open Supreme Court seat. Under the current system, we have something called the Judicial Nominations Commission that vets candidates for open seats on our state Supreme Court and then provides the governor with a list of 6 options. The governor makes his choice, and that person, he or her, is automatically seated on the Supreme Court. Every 6 years after that, the person has to come up for a retention vote on the ballot. We have a few Supreme Court justices on the ballot for their retention votes this year. The first substantive change, the first element of this amendment would require, once the governor makes his choice, the Senate, the legislative Senate, would have to approve that choice. It would have to confirm the choice of the governor. Now you might ask, well, how does this square with other states? Well, there's, I think, about 12 states out there that do it pretty much the way that we do it here without any confirmation on the part of the legislature. I think there might be about another dozen states that do allow the legislature to confirm. I'm fairly certain there might actually be 1 or 2 states that the legislature actually makes the determination themselves, but by far the most common method of Supreme Court placement is a popular election, a popular political election. The point being that lots of different states do this different ways in terms of putting or filling an open seat on their state Supreme Court. Right now in the state of Florida, Judicial Nominations Commission gives 6 choices to the governor. He has the discretion to choose, and it's not checked by anybody. The second substantive element of Amendment 5 has to do with something called the Judicial Qualifications Commission, not the Judicial Nominations Commission, but the Judicial Qualifications. And what this deals with, claims of wrongdoing or investigations on the part of, they could be Supreme Court justices or Circuit Court justices or any justices Right now, if somebody files a claim or charges a judge with doing something wrong, this commission will open an investigation. The files are confidential until such time that the Judicial Qualifications Commission believes there's enough there for an indictment. At that time, the file is open. It becomes public. But until they file an indictment, it is a confidential file. Legislature would like to have access to that file immediately. And so they want not to wait for an indictment to be filed. They would like access to those files of wrongdoing immediately, regardless of where the Nominations Commission stands on the issue. The final element to this change is a reduction in the threshold, the vote threshold of the legislature to overcome or overturn an administrative court ruling. This is not a ruling of a decision, so it's not like the legislature can come in and overturn a court case, but there are a variety of administrative procedures, filing deadlines, windows, things like that, that the court sets its own rules. Right now, under Florida state law, the legislature with a 2/3 vote can overturn an administrative court proceeding or ruling or rule. They like to lower that to simple majority, from 2/3 to a simple majority to overturn an administrative court procedure on the part of the court. Those are your three substantive elements. You can't vote differently, yes or no, thumbs up or down on all three of them. I'm going to start to Tony. Is this a power grab on the part of the legislature? What's going on here?
Let's say it's a balancing of power from their perspective. This one's a slightly different one, whereas the tax exemptions, the homestead exemptions were about your pocketbook. This is now about what the legislature is capable of doing. And I think there are some reasonable questions about power. For example, the House has the authority to impeach judges, but it can't see the files from the JQC, from the Judicial Qualifications Commissions to find out what the charges are until much later. So this file is actually not just making it public record and open to all the legislature, it's making it to the Speaker. And that some argue that that's a legitimate right. If they're going to be able to go through the impeachment process, they should know as soon as possible when something's coming up. Legislature changes every 2 years, as you know, and it could take a very long time for an impeachment hearing, and you don't want a crooked judge or somebody that's been accused of anything to wait out time and get past the legislature. I think the court rules also falls along those lines. There are provisions right now for the legislature to pass provisions for changes to the rules that the Supreme Court is using for the courts across the state. It is not often ignored. If those requests have come through, generally speaking, the Supreme Court does listen to them and make some changes. But if the Supreme Court chooses not to listen to the legislature, then there are no consequences. So there is an attempt to rebalance all of this. But I'll go back to, and maybe I'll play Aaron's job in this and talk about politics for just a second, because I'm not going to talk about the Speaker. I'll let you do that if you'd like. But the fundamental question on this one is, should the courts be tone deaf? Should they be making decisions absent input from the people who actually made the legislation? And those are legitimate questions for us to decide. Do you want your legislature to be much more flexible and your courts to be responsive to them, or do you want your courts to be independent? That's basically, I think, one of the context questions that's going on behind this particular question. So.
Judithanne?
Yes, whereas I said at the outset that we need to think carefully before putting in time-bound policy considerations that may be better suited to legislation and not put them into the Constitution, this actually is an example of an amendment that is very fundamental as far as separation of powers, checks and balances, how we want the Florida government to operate. So this is a very fundamental amendment. And to put it in political context too, it's this amendment which in several ways I think is trying to have more legislative control over the judicial branch. And so you did a nice job of kind of explaining what pros and cons that may entail. But the system that we have for our selection of our state Supreme Court justices, while there are 5 methods of judicial selection in the states that we already talked about, but ours is referred to as the merit system because this independent commission is supposed to come up with a list of names, irrespective of partisanship and partisan loyalty, than other systems. Political scientists have actually tried to study these different methods, and do we end up with different kinds of judges as a result of these different selection processes. But the attempt, while it is true that some states do have Senate confirmation, our system was supposed to be a merit-based system. And this amendment is coming in conjunction with calls for voters to consider not retaining there are three justices that are on the ballot this time. So you will be voting on whether to retain Justices Pariente, Lewis, and Quince. And so this is in conjunction with calls to remove those justices for what could arguably be for political reasons and objection to their decisions. So our framers in drafting our federal constitution and enshrining this concept of separation of powers, checks and balances, trying to provide for an independent judiciary at the federal level were principles that I think we should think about as well as far as the Florida government and how it works. And maybe you're going to talk more about the speaker, but I think obviously the question of removal of judges for cause and impeaching them is a very, it's an important issue. But the change to allow, before the process has really worked itself out and there's any justification as for the point of view of this commission, to go to the Speaker's office in advance of that process, I think is probably something we should also think seriously about. It seems, again, these seem to tend to skew towards more legislative influence over the judiciary. So for you to decide is whether you think that's a good thing or not.
Carol?
We're sitting here flirting with the inferences that there's undue influence on our judicial system. And ultimately, you have to remember Alexander Hamilton in Federalist Papers number 78 saying if there is no liberty of the judiciary, free from the executive branch or the legislative branch, there is no real citadel of justice. And our Florida Supreme Court is our citadel of justice. And we're up here kind of dancing around these inferences that we have legislative influence over our judiciary, and that scares me to death. So ultimately, I want a neutral magistrate overseeing, the justice of me and my brethren here. There's a reason why in our federal constitution we have this preoccupation with the rights of the criminally accused. And that inference bleeds into this discussion, which is if you want legislative influence over the judiciary process, then here you go. If you want to keep it separate and let the judiciary be its own neutral place, this is a bad thing.
Aaron, you're going to give us a little backstory on
Yeah,
the former speaker, aren't you?
the genesis of this amendment is actually pretty well known and interesting, I think. In 2010, the Florida Supreme Court knocked a whole lot of legislative constitutional amendments off the ballot. Basically said all kinds of bad things, whether they were poorly written, they weren't clear, that the intent of the amendment wasn't clear to voters. They essentially said, you can't do this. And the House Speaker, incoming guy named Dean Cannon from Orlando, said he didn't like that. And he was very, very clear and honest and said not only did he did not like that, he thought it was judicial activism, that essentially the judicial branch was telling his branch of government what to do. And in his 2 years as Speaker, which is now wrapping up, one of his top priorities has been to reshape that balance. And quite frankly, the result of this is Amendment 5, and if he was king, you'd be voting on a lot more than just what you're seeing here. He actually proposed much more, what most people would say would be punitive measures that would essentially shift more power to the legislative branch and away from the judicial branch. About the Supreme Court confirmations, one of the things he said is that it's good enough for the U.S. Supreme Court, why shouldn't Florida do it? It makes sense, that concept makes sense, but of course he's leaving out the fact that there is no merit retention for U.S. Supreme Court justices. They serve for life. And so it is a much more weighty decision than, for instance, having a chance every 6 years to throw the bum out if you don't like their how they rule. And you have that opportunity again this November. this is really interesting. As a reporter who's looking at a ballot that starts with Barack Obama versus Mitt Romney and then goes on from there, so many interesting things to look at. You can't help but notice and wonder about not only this amendment, but the retention of the 3 Supreme Court justices this November. You can only write so much about this, but it's really kind of interesting and important stuff. Really, for the first time since we went to this merit retention system, we have active political opposition of the Supreme Court justices for decisions they made. In some cases, the decisions they made in 2003, when they were retained in 2006 with 68% of the vote. And so it's just, I would say this. If there's one thing that I would do coming out of all this, I would take some time and read about all this stuff and get up to speed, because Supreme Court justices are going to be severely outnumbered in saying what can they say? We made our decisions based on law. That doesn't, I'm a student of political ads. I don't think that makes a very good political ad. And so it's going to be an interesting debate, and it's just one, this amendment and this discussion in particular, I think, is one worth following.
Okay, I'm going to move to amendment number 6. It's titled Prohibition of Public Funding of Abortions, Construction of Abortion Rights. And this is another amendment that has 2 distinct substantive components to it. Most folks here are probably familiar with the Supreme Court decision Roe v. Wade from 1973. Less might be familiar with something known as a Hyde Amendment, which has been routinely attached to federal appropriations bills since 1976. And what the Hyde Amendment says, it prohibits public federal funding of abortions, with the exception of rape, incest, or life of the mother. And this has routinely been attached to appropriations bills for the last 30 plus years. The first part of the amendment would put Hyde Amendment-like language within our Florida state constitution. And I believe, I took another look at that today because I had a question in an earlier forum on this amendment, that it applies not simply to abortions but to any health insurance or health benefits package that includes abortion funding or abortion benefits in it. The second component, construction of abortion rights, this actually goes back to an amendment that we put in the state constitution in 1980 that strengthened the privacy rights of Florida citizens. I believe that the language said something to the effect that every natural citizen has the right to be left alone and free of government intrusion in their private life. At the time, there was really no linkage or discussion about the implications for this clause in our state constitution for abortion or abortion rights. It's Article 1, Section 23. I skipped over that. But since then, and somebody can correct me if I'm wrong, we've had some court decisions in the state of Florida that have pointed to the state constitution as opposed to the federal constitution and said that women have stronger or more robust rights to privacy in abortion-related cases or issues than you might derive from our federal constitution. In particular, court decisions have struck down or found mandatory ultrasounds or mandatory parental notification as a violation of privacy rights, not necessarily privacy rights found in our federal constitution, but in our state constitution. The second part of this amendment would explicitly state that there is nothing in our state constitution that gives anybody greater rights, abortion rights, than can be found or derived from our federal constitution, and it explicitly repudiates any past court decisions that have made that determination. So let me stop there, and I'll start back with Judithanne, and correct me if I messed anything up, and just weigh in.
Okay, so there's the 2 parts. One is the public funding for abortion, and the second is about privacy, and it actually doesn't just say abortion, it says privacy. So with respect to public funding for abortion, that is correct. We've had the Hyde Amendment, and the U.S. Supreme Court has ruled on this case. In a case, Mara versus Roe, they said that the states do not have to provide funding for non-therapeutic abortions. And then in a follow-up case, Harris versus McRae, they said that the federal government does not have to provide funds for abortion. non-therapeutic abortion. So this is already a settled matter as it relates to what the federal Constitution requires, but puts the policy decision of whether to publicly fund abortions into the state constitution. It also includes that provision. It does say may not be funded for any abortion or for health benefits coverage that includes coverage of abortion. So presumably that affects me and all other state employees and others who are covered by state insurance. The second part, it is very broad language. One, they say that this will overturn any court decisions regarding that are interpreting Article 1, Section 23, and basically taking away our right to it says the right to privacy. So this is not just abortion, but it includes a whole host of other things. So for the first time, I think we would be voting to take away rights that we have right now. They specifically contrast with the federal Constitution, which is interesting, because the U.S. federal Constitution does not include a specific right to privacy. There's nothing that says right to privacy, whereas in Florida, Article 1, Section 23, we do have a specific, in the text itself, guaranteed right to privacy. So the Supreme Court first declared that we have a right to privacy in a case called Griswold versus Connecticut, which was dealing with the birth control issue. And the justices couldn't agree on where this right to privacy comes from. And in subsequent cases since, and that was in 1965, because there's not a textual basis, its strength in terms of being able to overturn state and federal statutes because of this right to privacy has wavered. But here in Florida, we voted in 1980 that this right to privacy was something important enough that it should be in the Constitution, and therefore a text that could be used to strike down legislation that infringes on that right. Not just abortion, but a whole host of other issues come under the privacy rights. Your right to determine whether you want medical care, who's going to make your end-of-life decisions. Those are privacy cases, for example. So it's not just abortion. It specifically says your right to privacy and any court decisions interpreting that right to privacy here. So it's very far-reaching amendment. So, yeah, I would encourage you to think carefully about that.
Thank you, Judithanne. Tara, any comments?
You know, I find it interesting to talk about this because, as Judithanne said, our federal Constitution doesn't have an explicit right to privacy. It's a conundrum, right? It's a shadow of inferences coupled with a number of amendments. I don't know why, if we don't have a federal right to privacy, and we've codified it in our state constitution, and we've worked so hard through the Supreme Court to find that right to privacy, why we want to strip it out of our own Constitution, right? The Supreme Court couldn't find it explicitly because it's not in there, so they coupled a bunch of amendments and said there's a shadow cast by it. That's what Griswold versus Connecticut really says. And if we have it in the state constitution here in Florida, why do we want to get rid of it? Yes, it's politically charged because it's about abortion, and a lot of opponents of abortion want to take this away as sort of this open door to create state legislation, to create obstacles to women seeking abortion. That's true. But there's more to it than that, and that's only one part of your right to privacy. Right to privacy is also meant your right to privacy in your bedroom, you know, not just your right to privacy to health care, but those things too. Those are fundamental freedoms that you identify with, okay? And so this has broad reach, like Judithanne says, and I want you to consider that. Why would we want to take it away if we worked so hard in the Supreme Court to get it in the first place?
Gentlemen, you want to weigh in? I'm exactly on time right now. Running a tight ship here? Or I'll say it. No.
I will. I think that I'll paraphrase some of the things that were said in the legislature at this time, not about the specific issues about abortion, but that the public has a right to express its opinion. And I think this is one of the most direct ones, with the exclusion of, there are broad questions related to the privacy issue. But this is the most clear. Since the 1970s, we have been discussing whether abortion rights and limitations to abortions are something that people want. This is probably the most direct amendment we have on the ballot in terms of it is what it is. You're seeing it. Yes, there's this hidden discussion about privacy, but it is about abortions. I'll add maybe some political color in this case. It's that many of these amendments are sometimes brought forward because they will attract certain